Good morning, and thank you for joining us. My name is Peter Bohr, and I'm the Executive Vice President of the Maine State Chamber of Commerce. Our program this morning is brought to you in partnership with the Maine State Chamber of Commerce and Pierce Atwood. There are a large number of people on this program and signed up for this program. So asking questions orally will be impossible. There is a chat function which some of you have already accessed at the bottom of your screen, and that will allow you to type in questions as the presentation goes along. We do plan time to take time at the end of the presentation to answer your questions, although it is a lengthy presentation, we're covering a lot of ground. To that end, we think today's program covers some of the most pertinent and pressing issues employers have around the pandemic and how that is impacting every business in the state of Maine. We are extremely lucky to have as our presenter this morning, Katie Rand. Katie is a partner in the firm of Pierce Atwood. Her primary practice involves employment law with a focus on discrimination, wage and hour violations, harassment, and retaliation issues. Katie is a certified Title IX investigator, and she regularly conducts independent investigations for employers, education institutions on a wide range of issues, including sexual harassment and sexual misconduct. In between college and law school, Katie worked in the private sector, including L.L. Bean's and Hannaford Brothers. She is a graduate of Beale College, where she earned her BA and her law degree from the University of Maine Law School. She is also the current chair of the Maine Labor Relations Board. Before I hand it off to Katie, I want to let people know, and we said it at the beginning, but we are recording this presentation, and we intend to make it available on our website afterwards. So with that in mind, Katie, thank you for joining us. Thank you for doing this with us, and take it away.
All right, I'm happy to be here. I took a look at the registration list, and there were a lot of familiar names, a lot of unfamiliar names. I saw some really large companies represented, some really small companies represented. And, you know, I saw some companies that I think are probably struggling with lack of work, and others that are probably have plenty of work because they're essential and are struggling with how to figure out how to keep their workforce together. There is something for everyone, I think, in the presentation today, but not everything is going to apply to everyone. So as I go along, I hope you'll just be thinking about what applies to you, and take the pieces that mean something to you and not the pieces that don't. I'm going to cover a lot of ground. And I'm going to try and advance my slides. Yeah. Sorry, guys. Oh, there we go. All right. I'm going to start by talking about extreme public health emergency leave. This is a state statute. It applies to all of you. This statute's been on the books since 2005 and was enacted, I think, in response to the bird flu epidemic. To my knowledge, it hasn't been previously invoked, or at the very least, it's not a statute that I've ever been asked to give guidance on. It requires that employers provide reasonable and necessary leave. The leave can be unpaid, and there are a number of reasons set out in the statute, many of which could be triggered by the circumstances today. So an employee in isolation, an employee that you're asking not to come to work because you're afraid that they may expose others, an employee under quarantine, and an employee who's needed to provide care or assistance to a spouse, domestic partner, parent, or child. We got a question ahead of time from an attendee who asked whether this last bullet would apply to an employee who needs to be home to take care of a child because school is closed, for example. The short answer is unclear, but I would expect this statute to be interpreted broadly, and I would assume that yes, this statute would provide unpaid leave for somebody who's unable to come to work because they need to care for a child. There are some exceptions in the statute that are expressly spelled out. The first one is one of the most important, which is nothing about this statute prevents you from taking steps that you need to take to protect your business. For example, furloughing or laying folks off if there's a lack of work. If there's a lack of work, an employee doesn't need leave from work. So you're still free to take those actions if they're justified by legitimate business need. The second prong, you can deny leave to somebody who fails to communicate that within a reasonable period of time. Under the circumstances, most of the need for leave that I can imagine are going to be emergency, so I don't see that coming into play very often right now. And finally, if you're a public employer and the employee's services are necessary to protect public health and safety, you can deny the leave. All right. Moving on to the harder stuff, I hope most of you have heard of the Families First Coronavirus Response Act. It's a new federal law that employment lawyers have been feverishly digesting over the last few weeks. We did have a couple weeks advance notice before it went into effect, but it has been effective since April 1st, 2020. Importantly, this statute, which provides for paid leave under certain circumstances that we'll go into in a second, it only applies to employers with fewer than 500 employees. It does apply to even the smallest employers, however, though we'll talk in a minute about a possible small business exception to the statute. When it comes to employment laws, often employers are in the position of trying to argue that they have fewer employees than whatever the threshold is in the statute, right? Because statutes usually apply when there's a minimum number of employees. In this situation, a lot of employers would like to take the position that they're too big to be covered by the statute. The same laws that apply in other sort of employment contexts that will sometimes look to take two affiliated companies and mush them together and count both of their employees for purposes of determining if a statute's triggered. Those tests apply here, and I'm not going to go into what those tests are other than to say that if there are two closely affiliated companies, or if two employers, like a temp agency and the employer where they're assigned, share control over an employee, sometimes those companies' employees will be counted together for purposes of determining if you've met the 500. I would urge businesses to be careful about reaching out and trying to aggregate employees from affiliated companies in order to get above the threshold so they don't have to provide this law. And that's because positions taken with respect to this law could come back to bite you in another context. So if, for example, you take the position that you're a big employer for purposes of this statute, don't expect to take the position that you're under 500 when you're sued for a discrimination claim, for example, and want a lower damage cap to apply to you, okay? The statute provides up to 2 weeks of what I'll call emergency paid sick leave, and that's either going to be at full pay or 2/3 pay, depending on the reason for the leave, and there are caps that I'll talk about in a minute. And it also expands the FMLA to cover individuals who are unable to work because they're caring for a child whose school or daycare is closed, okay? And that's 2/3 pay, subject to a cap. Critically, amounts paid to employees for either this emergency paid sick leave or the expanded FMLA are reimbursable, and they're reimbursed through a payroll tax credit. And I'll talk to you in a minute about how that works. What you're looking at now are the reasons that an employee might be entitled to paid sick leave. So the employee is subject to a government isolation or quarantine order. That is essentially everyone in Maine right now who is working for a non-essential business, right? Because those who are not working for essential businesses or who are doing more than minimal operations are not permitted to be going to work right now. Second, an employee who has been advised by a healthcare provider to self-quarantine. And for this provision, healthcare provider means the same thing here that it means under the FMLA in terms of what kind of a provider can certify an employee's need for leave. That's going to be a doctor, a nurse practitioner. There are certain specified healthcare providers that could advise an employee to self-quarantine and trigger this leave entitlement. If an employee is experiencing symptoms and is seeking a diagnosis, and the seeking a diagnosis is part of the test, and so the Department of Labor has told us it's not enough to say, I don't feel well, I'm going to stay home, that the employee at least has to be making some attempt to be seen or tested. The employee is caring for an individual who's either subject to an order or has been advised to self-quarantine. And the Department of Labor tells us this individual can't just be any individual. It has to be a family member, someone in the household, someone where there's a reasonable expectation that employee would be providing the care. So employee can't go into the business of caring for people who are under self-quarantine, for example, and get leave. Employees caring for a child because school or daycare is closed. Department of Labor tells us this means that they need the leave in order to care for the child. So if there is another parent in the home who is available and capable of performing that care, then there would not be a need for leave there either. And then there's a little catch-all bullet, and we don't have any guidance on what other things yet might entitle employees to this leave. So starting with the paid sick leave component, all of your employees, if you're subject to the law, all of your employees are eligible, regardless of how long they've been employed by you, regardless of whether they're full-time, part-time, except, and this is an important except for many employers, employers may exclude employees who are healthcare providers or emergency responders. The healthcare provider exception is more broadly applicable, so I'll focus on that. I told you a second ago that a healthcare provider, that term for purposes of understanding who can direct an employee to self-quarantine, that term is fairly narrow. It's a doctor, a nurse practitioner, some other specified healthcare providers. In this context, who could be excluded from the leave? The Department of Labor has defined it quite broadly to include all employees, not just those who are providing direct care, but all employees of, and there are a number of enumerated types of providers in the law, in the regulations. And I haven't listed them all, but if you feel that you are similar to one of these, you are probably in the list. You should consult the list, but are probably in the list. So there's broad permission for those who provide healthcare to exempt their employees from this law. The Department of Labor has urged employers to be judicious about how they invoke this exception, mostly because we do still want employees who ought not to be coming to work because they might infect somebody to have the support they need to stay home. But the exception's broad. The amount of this paid sick leave, full-time employees, and that's defined as those who work at least 40 hours a week or scheduled to work at least 40 hours a week, get 80 hours of paid sick leave. Part-time employees get an equal amount prorated to cover 2 work weeks. And the DOL tells us if there's no normal part-time schedule, you calculate looking at average daily hours over the last 6 months. All right, how much? There are how much you need to pay in sick leave depends on why the employee needs the sick leave. So if the sick leave is taken for the employee, him or herself, because they're under quarantine, they've been advised by a healthcare provider to stay home, they're sick and seeking diagnosis, it is pay at the regular rate, capped at $511 a day. If it's care for another person, the other reasons, it's 2/3 the regular rate, capped at $200 a day. Regular rate in this context is, a tricky term. It's a term of art, just like it is in the Fair Labor Standards Act context. Be careful that you are including other payments beyond the hourly wage or the salary that an employee receives that need to be included in the regular rate. So non-discretionary bonuses, for example. The statute tells us to look back 6 months to figure out what the employee's regular rate is. It's possible that there are other payments that have been made to the employee that need to be factored into that. So that's the paid sick leave component. The expanded FMLA component is available for only one reason, and it's to care for a child whose school or childcare is closed because of COVID-19. So it's much narrower, the circumstances under which somebody will be entitled to FMLA. If somebody needs to be out of work because of school or childcare being closed, they'll be entitled to both the paid sick leave and this expanded FMLA. And this expanded FMLA dovetails with that paid sick leave insofar as the first 10 days of this expanded FMLA are unpaid, except remember the employee will be entitled to 2 weeks of paid sick leave. So if they have not already used that for some other reason, the first 2 weeks of this leave for those who are out to care for a child will be paid at 2/3. And then the remainder of this expanded FMLA is paid at 2/3 the regular rate. So that means that an employee who needs leave because of childcare reasons will get up to 12 weeks of leave paid at 2/3 the regular rate. This expanded FMLA is adding another reason to the list of reasons that an employee can take FMLA, which those of you who are subject to FMLA are probably familiar with: serious health condition, to care for someone with a serious health condition. And so if an employee has already taken some FMLA earlier in the year, let's say because of a serious health condition or birth of a child, the amount of leave that's available to them under this expanded FMLA will be less than an employee who hasn't. All right. I know that there've got to be a number of people on who are interested in the small business exception. Employers with fewer than 50 employees can be exempt from the child care related leave. So not the paid sick leave that's needed because an employee needs to self-quarantine or is sick and seeking a diagnosis, et cetera, but the child care component of the leave. And to claim this exemption, an authorized officer of the business has to determine and document in good faith that providing the leave would effectively put the business underwater and not allow them to continue operating, even at a minimal capacity. Or that the nature of the employees, they have specialized skills, business knowledge, responsibilities, that the nature of the employees are such that there's an extreme risk to the business's financial health if they're not at work. Or that you just simply don't have enough workers to continue to operate the business even at a minimal capacity. So if any of these circumstances apply to you and you're a small business, an authorized officer of the business should document this. You are not required to, and in fact, the DOL has asked you not to send them any documentation. You don't need to apply for an exception. Whether they, after the crisis, go back and probe the circumstances, I think remains to be seen, but it would be important to have this documented and to be able to say in good faith that providing the leave will trigger one of these bullets. There is a posting requirement. When is there not a posting requirement? There is a posting requirement. There is a new poster to add to your collage of posters, and all covered employers, even those that plan to claim that small business exception that I just talked about, are required to post. And I've told you where you can go get it. And there are a number of ways you can fill your poster obligation. If you don't have folks in the workplace anymore, then putting it in the break room is unlikely to be effective. So you could mail it, email it, or put it on your website, but there is a poster requirement. Just to make sure that we're all thinking about leave and when leave is needed. A couple of slides. So an employee is going to be entitled to leave only if there's actually work available for the employee in the workplace or remotely, and the employee can't do it for a covered reason, one of the reasons that we just covered. There are, especially right now, there are a number of situations in which an employee may not be able to work for one of those protected reasons, but they're not entitled to leave because there's no work to be done. And I think this is an important distinction. So if an employee is furloughed, and this goes for a furlough before April 1st when the law went into effect, or a furlough next week, if you as a business make a determination that there is a lack of work and that employees need to be furloughed, that employee no longer needs leave. There's no job for them to do, okay? The same is true if the business itself has been partially or completely shut down as a result of a government order. So restaurants, for example, that had dining rooms that were shut down, earlier in March, if those servers no longer had any work to do because the restaurant was shut down, that employee does not have a job that's going on that they need leave from. And I'm assuming that those servers couldn't telework. But a note about telework, if there is telework available, if the employee can do their job from home, while caring for a child, while under self-quarantine, that employee does not need leave. That employee's working, right? They don't need leave from their job. And an employee also doesn't need leave if you and the employee agree that even though employee usually works 9 to 5, there's no reason employee can't work, those hours. Husband comes home, for example, can take care of the child in the afternoon. Instead of working 9 to 5, employee maybe works, 2 to 9. That's an employee does not need leave if you and the employee agree that they can continue to work off hours. So it's important to think about, is there work going on either at home or in the workplace that employee could do but for their inability to do it? If so, leave. If there's no work for them to do at all, no leave. And we'll talk about unemployment in a minute. A word about the tax credits. So the complete cost of providing paid sick leave and the expanded FMLA, and that includes certain health plan expenses, are reimbursable. Amounts that are not required to be paid presumably aren't reimbursable. And that's why understanding whether leave is required or not required is important. And that's why I spent some time a minute ago on the is there work or is there not work. If your business is shut down and you pay employees nonetheless to stay home, that's very generous. You are unlikely to be able to get a tax credit on that because those employees are not on leave. So that's important. The way you practically get this money is by holding back payroll taxes on wages and compensation paid to employees broadly. Okay, so if you have, 2 employees who are out on this paid sick leave and it's $1,000 a week to them in wages, you may hold back payroll taxes on all employees on leave or not on leave, sufficient to cover that amount. And if at the end of the quarter, you were unable to hold back enough payroll taxes to make yourself whole for those paid sick leave and expanded FMLA wages, there'll be a refund at the end of the quarter. So that's what's reimbursable and how you capture the reimbursement. I've got a lot of questions about documentation for a couple reasons. One, employers want to make sure that they have what they need to convince the IRS that they are entitled to this reimbursement. And two, in the regular FMLA world, employers are accustomed to getting certifications for an employee's need for leave. The Department of Labor, the guidance that they have issued has said that employers can require from employees whatever documentation the IRS says they need in order to substantiate the credit. The IRS, in turn, has told us that this is what employers need to substantiate the credit. They need a written leave request from the employee that has the employee's name, the dates of leave requested, an explanation of what the qualifying reason is, and a statement that the employee is unable to work. And then there are some additional bullets that are situational. So if it's based on a quarantine, just a description of the government entity or the identity of the healthcare provider that's advising it. If it's to care for somebody else, the name and relation of the person that the employee is caring for. If for children, who are these children? How old are they? Which school is closed? And a representation that there isn't somebody else in the home who can provide that care. And if it's for a child over 14 years old and the need is during the day, some kind of a statement that there are special circumstances. that exist that would require an employee to be home. So that's the documentation that's required. I think, there's a recognition here that requiring employees to get a note from their healthcare provider right now that they've been advised to self-quarantine because they maybe have been exposed or have some symptoms is not practical in light of the fact that most consultations are happening via telemedicine, and the doctor's office have a lot of competing priorities right now. All right, some of these Q&As, I'm going to do this after each section. A few of these Q&As came in pre-webinar. Others are ones that I've just heard repeatedly from clients, and so suspect you may be wondering. Is this statute retroactive? You have, for the last 2 weeks of March, just tried to bridge your employees until you would have some guidance around what was required, and you have been paying employees who need leave out of the goodness of your heart. No, it is not retroactive. You will not be rewarded for your good deed. You still need to provide the leave in the statute after April 1st, and you won't receive a tax credit for the leave that you provided before April 1st, unfortunately. Can you require employees to use PTO? So you have an employee who has a good size PTO bank, earned time bank. Can you require them, and let's say you have an employee who's going to be out for childcare reasons, so they're only going to be entitled to the 2/3 pay. Can you require them to use PTO to supplement that, for example? With the paid sick leave component, the first 2 weeks, the answer is very clear. No, you may not. The employee could elect to do that, but you cannot require them to. With the expanded FMLA component, the answer is unclear, and I will only say this when I absolutely have to. I hate it when lawyers say it depends or we don't know, but we don't know. We have regulations from the Department of Labor. There are inconsistencies in those regulations. There's a point at which the Department of Labor says the employer can require and the employee may insist on using their PTO to supplement. And there's another regulation that says neither employee nor employer may insist. I don't have the answer to that question, so I suggest to you that it would be risky to require an employee to use PTO to supplement expanded FMLA, at least until we have more guidance around that. This is probably the most common question. Is intermittent leave available? So particularly for some of the reasons that someone might need leave, if their job can't be done outside of the workplace, then obviously they can't do intermittent leave. An employee who is experiencing symptoms of COVID and is seeking a medical diagnosis may not come into work part-time while that's happening, right? But an employee who needs leave for childcare reasons might be able to secure part-time childcare and might only need part-time leave. The answer is yes. If an employee can telework, or if the need for leave is childcare related, intermittent leave is available, but only as long as the employer and the employee agree. So this is a little bit like leave after the birth of a child, for those of you who are subject to the FMLA, where it can be provided intermittently, but it is not required to be. And that's the case with this kind of leave. So, this is great because it gives you flexibility, and there are certainly a lot of employers for whom the nature of the business and the need for workers is such that you'd be thrilled to have an employee still come to work 3 days a week and take 2 days a week to care for their child. There may be others where it's just really not feasible, and you do have that flexibility. And by intermittent leave, I mean leave in any increment that employer and employee agree to. So it doesn't have to be a full day. It could be a half a day. It could be 3 hours each day. And obviously, just like intermittent leave under FMLA, if the employee is using less than a full week, you only charge what they're using against their leave entitlement. So that'll drag out the number of weeks over which they could be entitled to leave. I think I already answered this, but how does prior use of FMLA affect the leave entitlement? It does not affect the eligibility for paid sick leave. It does affect their entitlement to that expanded FMLA. And this creates a little bit of an odd, I don't know, outcome or policy result, which is this expanded FMLA is available to employees who have been with you for more than 30 days. So it's very possible that you will have an employee who was hired in March or February who has a full 12 weeks available to them for this leave, while somebody who's been with you for many years has less available because they already took some FMLA earlier in the year. And that is what it is. All right, time check. All right, switching gears to talk a little bit about unemployment. And there have been a couple of developments in the unemployment realm in the last month at the state level and at the federal level. Starting with the state level, the first change we saw last month was an expansion to state unemployment benefits. So benefits that are paid to an individual who's temporarily laid off or dislocated as a result of this COVID-19 state of emergency will not be charged against employers' experience ratings. That's obviously great news for those who pay into the system. That was very not rewarding to those who are direct reimbursers, which for those of you who aren't, that simply means those are employers who are not paying into the system, but who instead reimburse the Bureau directly for claims paid out. I have something for you too in a few slides. Eligibility under state law for unemployment was expanded to include employees who are under a medical quarantine, who are temporarily laid off due to lack of work, or on a temporary leave of absence due to quarantine, risk of exposure, or need to care for a family member. The requirement was that employees remain in contact with the employer and be able and available to return to work when appropriate. And so this initial expansion was to recognize that there are going to be situations where employee has no income, but still has a job, has no income for COVID-related reasons, but still has a job, and everyone intends this employee to return. An employer may still be paying employees health insurance, and that too will not disqualify an employee under the main expansion. The bigger news came more recently with the CARES Act, and this is the same statute that brought us the Paycheck Protection Program that I'm going to touch on a little bit at the end of the presentation. There are two key components. I'm oversimplifying a little bit, but there are two key components to CARES Act and what it did with unemployment. There's something called pandemic unemployment assistance. That provides benefits to individuals who are not otherwise eligible under state law. And I'm going to break these down. And then there's federal pandemic unemployment compensation, and that's the $600 bump up that everyone's heard about that's available to individuals who are eligible to receive a benefit under state law. That bump up is also available to those receiving the first bullet. I'll dig in there for a sec. So starting with this first pandemic unemployment assistance, it applies from end of January through this year. It's capped at 39 weeks, so that's longer than the typical state unemployment program. And it covers workers who are ineligible for unemployment under state law, either because they've exhausted, they're self-employed. So this expands unemployment to independent contractors. And so these workers need to also be able to certify that they're unable to work due to one of many COVID-19 related reasons that I'll tell you about in a second. This category of workers are entitled to unemployment in an amount that would be determined under state law, plus an additional $600, okay, which is the federal pandemic unemployment comp. This is available for full and partial unemployment. Okay. To be eligible for this pandemic unemployment assistance, a worker needs to be able to self-certify that they're capable of and available for work, but they're unable to do so right now because of one of these articulated reasons. And I won't read through all of them, They're probably familiar to you right now, but you'll see that I've underlined one, which is that the employee has had to quit working as a direct result of COVID-19. That strikes me as extraordinarily broad. It's unclear how that will be interpreted. All right, so that first bucket, that's benefits for employees who wouldn't be eligible to collect under state law, either because they've exhausted, they're unemployed, they're self-employed, or they're taking leave for one of these COVID-related reasons. This second bucket applies to all individuals on state unemployment, regardless of why. So if you terminate somebody not for gross misconduct, so that employee is entitled to unemployment, that employee will get this $600 bump up. It's not tied only to COVID-related circumstances. And it's available to anyone who's collecting state unemployment, full or partial. One thing to back up, I don't think I noted it on a slide. These benefits are available once the state enters into an agreement with the federal government, because these are amounts that the federal government is going to reimburse the state. The state is going to continue to administer unemployment. As of this morning, it's not clear to me that Maine has yet done that. I'm sure they will. There's no reason that any state would not take advantage of this, but there is some red tape. So you should not assume that these additional amounts would be available were an employee to apply today, or that if a self-employed individual or independent contractor were to apply today, that their claim would be accepted by the state. According to the website, they're still sort of putting some things together, and they're keeping that updated. So if timing is important, check the Maine website to see when these benefits are in effect. This second piece waives, and this is also true under the state unemployment expansion. The first week of unemployment is covered. The waiting period is waived. That's true under this federal expansion as well. For the handful of people who are on, or maybe there's more on, that are direct reimbursers, so who would not benefit from their experience ratings not being dinged, there is some relief in the CARES Act for you. The federal government will pay the state 50% of all claims that are paid to your employees between March 13th and the end of the year, and the state in turn is required to use this money to pay you back. Okay. I've also received a number of questions about whether direct reimbursers are going to be responsible for that $600 bump up or add-on. Our read of the statute is that this $600 add-on is paid directly to the states. It goes from federal government to state to employee. And so we don't see any basis in the law to pass that back along to a direct reimburser. There are some practical implications, good and bad, depending on how you look at it or what your perspective is. Because this $600 a week add-on to what an employee is earning under state unemployment, because it applies across the board, because it applies to partial, there are a number of circumstances where an employee will earn more on unemployment than they would earn working. And so I've given you an example on this slide of a full-time employee that's earning $15 a week, bringing home $600 a week. If laid off, that employee's benefit would be about $355 a week. You add the $600 and this employee is earning significantly more on unemployment than they would be to work. Okay. A number of employers have expressed concern that this practical impact, combined with the very broad statement in the pandemic unemployment assistance that it's available to anyone who has had to quit working as a direct result of COVID-19. Many have expressed concern that this is going to result in a flood of people quitting, purportedly as a result of COVID-19 and trying to get into the unemployment system. The Federal Department of Labor has been really clear in recent guidance that the states are still expected to police unemployment fraud, and they're expected to deny claims where an employee has work available to them, or the employer is prepared to continue paying them, and they're nonetheless running to the system. So I can't answer the question of how real this concern is. I certainly understand why people have it. It remains to be seen. All right, a few unemployment common Q&As. I think I've already answered this, but still nobody believes it, so it bears emphasis. Will all employees get the $600 add-on regardless of why they're on unemployment? Yes, it is not just for employees who are laid off because of a shutdown or unable to work for a COVID-related reason. This expansion is available, and it's available to the self-employed. I touched on this as well. The benefit's so generous. How can I prevent employees from self-selecting unemployment? Hopefully, the Bureau is applying the same general rules in policing unemployment claims, and hopefully an employee who self-selects out of work when they have work available, hopefully their claim will be denied. But that won't prevent them from applying for unemployment or from believing that perhaps they'd do better. So if this is a reality, if this concern is real to your business, I think you do need to be thinking about how you will incentivize employees to continue to be contributors in the workplace. For some, job security and health benefits, and knowing that they have a continued relationship with their employer, so that when the crisis passes, they'll have a job and can return to normal. For some, that will be enough. For many, that will be enough. For others, though, employers might need to consider some kind of a hazard pay, a risk premium pay, to keep employees incentivized to work, notwithstanding the risks. I think we all recognize that it's for those who are continuing to go into work because it's an essential business. There's fear. They are taking a risk by doing that. They're doing important work, and so there are employers who are beginning to think about paying some kind of a hazard pay, just an additional amount per hour, for example, to keep those employees incentivized to work as they look and see some of their coworkers who are collecting unemployment, perhaps totally legitimately, but are earning more to do that than they are to put themselves at risk and go to work. So something to think about. I've already answered this question. All right, I could tell from the Q&As beforehand that there are a number of people who are interested in learning more about the Paycheck Protection Program in particular. When we put this webinar together, the focus, I think, initially was really to be more on the leave issues and the things that we've already talked about. But given the amount of interest in this, I want to spend some time talking about this. And I'm happy to talk more about this offline because this isn't interesting to everybody. Here are some of the basics around the Paycheck Protection Program. And just so you know, I have heard from clients who as early as late Friday afternoon were receiving word that their loans were approved. So this is in full swing right now. And if this is something that you're eligible for and that you're interested in pursuing, I would urge you to talk to your banker or your lender as soon as possible, okay? These are loans available to employers with fewer than 500 employees, some with more than 500. This sort of size test is a little bit complicated and way beyond the scope of this webinar, but there are circumstances where different employers will be treated as affiliated and their employees counted together. There are other situations where they won't under this program, particularly in the hospitality industry, okay? The loan is available, it's allowed to be used on certain enumerated categories of things. Payroll is one of them, mortgage interest, rent, and utilities. So that's the purpose of this loan, is to keep you running. If it is used for these purposes in the 8-week period immediately after loan origination, so if you get a loan today, you have the next 8 weeks to spend the money on these purposes. At least 75% of the money has to be spent on payroll. If you do those things, it's eligible to be forgiven. Yes, that means free money. The forgiveness component is discounted, so it gets eaten into, your forgiveness gets eaten into if you reduce your full-time equivalent, or if you reduce salaries more than 25%. So that's an overly simplistic explanation, but I think what you need to understand is the purpose of this loan is to enable employers to continue paying their employees and to not lay them off or cut their pay more than 25%. If you take out a loan and nonetheless reduce your headcount or salary significantly, you'll not be eligible for full forgiveness. And I should say that there's nothing in this payroll protection program that says you need to use the money to pay employees who are working. You could get one of these, continue to pay your employees and pay them not to work. The maximum loan that a business can obtain is 2.5 times the average monthly payroll costs. And this term payroll cost is important in the paycheck protection context because it comes into play several times. Number one, it tells you how much you can get, 2.5 times payroll costs. Number two, it's a permissible, allowable spend for the money on payroll costs. And number three, you have to spend at least 75% of it on payroll costs in order for it to be forgiven. And so understanding what's in and out of payroll costs is important. And I've given you some guidance on that here. I think importantly, what's out, importantly for some businesses, what's out is compensation over $100,000 in salary. So you will, if you take out one of these, you will only be able to borrow and spend the money on up to the first $100,000 if you have highly paid individuals. The loan terms are extraordinarily advantageous, even if you're not able to get forgiveness. So if folks think they might be eligible, I encourage you to explore it. And I will also say that sole proprietors and independent contractors are eligible to take out these loans themselves individually. And there's a different definition of payroll costs for them. So, a sole proprietor may not have wages, costs of providing health benefits, retirement contributions. The way their loan is measured is in reference to their self-employment income up to $100,000. The other benefit that's possibly available to folks under the CARES Act, there are a number. These are the two that I'm choosing to highlight because I think they're complicated and the most worth talking about. This employee retention tax credit is not something that you can do if you get one of those PPP loans. It's an either or proposition. So if you don't qualify for one of those loans, or if for whatever reason, choose not to seek one, this is an option that's available to you. It's available to businesses that were operating in 2020. To be eligible to take this tax credit, you have to either have been partially or completely shut down per government order. So that'll apply to a lot of restaurants, hospitality, for example, many others too. Or you have to have experienced a 50% decline in quarterly receipts as compared to the prior year. So there are two ways to qualify. You're either partially or completely shut down, or your quarterly receipts have declined at least 50% compared to the same quarter last year. If you meet those criteria, what you get is a credit on 50% of your employees' wages, up to $5,000 per employee. You recoup that credit. It's similar, a little bit different from, but very similar to how I explained you would recoup the credit under the FFCRA. You get to hold back certain payroll taxes to pay yourself for this. And then at the end of the quarter, there's a true up. But it's capped at $5,000 per employee. So it has limited utility, maybe more utility for an employer with a lot of part-time employees, right? Because it would take you longer to get to that $5,000 credit. This is also really important. If you have under 100 employees, you can take that credit, 50% up to $5K, on employees who are working, on employees who you're paying to stay home, but just want to continue to pay, on any. If you're over 100 employees, you can only take the credit to the extent you are paying wages to employees who are not working. So you're paying them to stay home, essentially. And that's when you'll have to get into an analysis of what are my employees, am I and are my employees better off with me taking this credit and paying them not to work, and I get my $5,000 credit per employee? Or are these employees better off with me furloughing them and they go to the unemployment system, which would be a perfectly permissible claim for unemployment? And as you know, and your employees may do better on unemployment than they would if you continued to pay them. I wish I could sort of slice and dice that, but sort of which option is best for each of you, it's so dependent on who your employees are, whether you're being impacted, whether you think now is the worst of it for you, or whether you think the worst is coming, whether you qualify for a loan. There's just no way for me to be more specific. That is the content, and remarkably, we have about 5 minutes left. I didn't know if I'd still be talking at 12:30. Peter, do we have anything from the audience?
Oh yeah, we have a lot of questions. And I'm gonna, because of the volume of them, I'm just gonna have to pick and choose and read them. So I'm gonna start towards the top. Under the FFCRA, commissioned employees' hourly rate for the leave is an average of commission for the past 6 months. We pay our employees an hourly wage plus commission. Do we need to add in their commission average to their hourly rate?
I don't totally understand the question. I think it depends. I think the question is whether commissions generally are part of the regular rate. I'm not going to take, that's a more complicated, nuanced question than I want to take here. The short answer is that whatever you do for purposes of paying somebody overtime is how you're going to calculate their regular rate here. And so it could include commissions. It could include certain other things like non-discretionary bonus payments.
There's been a number of questions, Katie, about concern from employers who say people who are making more money on unemployment insurance. I'm concerned what happens when I bring them back to work and they revert back to less money.
Yeah.
And how do I handle that? I don't think there's any good answer for that question.
I think, yeah, I think you're right.
$600 is time limited. That's the other thing they need to remember. It is a time limited benefit.
That's a really good point, and I don't think I said that out loud, though I think it was probably on one of the slides. This $600 add-on to state unemployment it starts when the state enters into these agreements and it expires in the end of July. Now, will Congress do some sort of expansion of that? I don't know. They could. But if they don't, then at the end of July, employees will revert to a more traditional unemployment test, which, I mean, as everybody knows, the reason that unemployment, it doesn't exceed wages that the reason it's a fraction of the employee's wages is to incentivize employees to return to work. If though you're ready to bring people back and it's a time when they could still be collecting that additional $600, I don't have an easy answer for you, other than the fact that they ought not to continue to qualify. And that you may ultimately, depending on your situation, need to get into being a little bit creative and paying them some sort of hazard pay. It's not necessarily going to bring them up to the full unemployment amount, though.
Does shutdown per government order include state/court orders? And then it says law firm - litigation, shut off court events for last at least 6 weeks.
So I'm going to assume that we're talking about the FFCRA, and one of the reasons that an employee would be entitled to paid sick leave is that the employee is subject to a quarantine order, but that doesn't really apply here. So I'm not totally sure what shutdown he means.
It sounds like it might be a law firm that's impacted by the court order. That's how I interpret it.
Okay, so if we're talking about the employees of a law firm and a bunch of work, I mean, I'm impacted by that order. I'm doing only advice and counsel right now and no litigation right now. But that wouldn't, I would not say that is a partial or complete shutdown of the business. To the extent there's work for the people at the firm to do, either from home or in the office. If they can be in the office, those employees wouldn't be entitled to leave. If there isn't, then they might end up being, if there is no work for them, then they also wouldn't be entitled to leave because they'd be essentially furloughed.
I think I understand this question. It says, can vacation and sick time accruals be turned off during this time? I'm assuming people are laid off or furloughed and not working.
Yeah, it depends on your, so right now in Maine, and I'm just speaking of Maine, there is no paid time off law or vacation time law. So employers are not yet, at least before next January, legally required to pay PTO or vacation. That means that they control the terms under which somebody earns PTO and vacation. And so my answer would be that you have a lot of flexibility around when an employee earns or doesn't earn PTO or vacation, but you're probably constrained by your policy. So before you make any changes to how it's earned, look at your policy, and if you're making those changes on a go-forward basis, then you might need to change your policy.
I've got 3 questions. One is off topic, but I hadn't thought about it. Although the impact and the intersection of workers' comp and COVID-19 is a real issue out there in terms of compensability if someone's exposed at work. But the other question I was asked on here was, what if you have people working from home and they're injured at home and they're technically working, doing telework? Would that potentially be a compensable injury?
Yep, with the caveat that I am not a workers' comp lawyer, and Alan Muir, who I could knock on the wall and have him come in and answer, but I won't put him on the spot like that. But so the caveat that this is not from a workers' comp lawyer, I do think that as community, starting with the first part of that question, as community spread becomes more and more prevalent, it's going to be increasingly difficult for employees to establish or employers to know whether the exposure to COVID happened in the workplace. Maybe easier in the healthcare context, but so I suspect that's going to be a litigated issue in the future. That second part, though, employees who are working at home and who suffer some kind of a non-COVID related but work-related injury while working at home, yeah, that's absolutely a concern. That's a concern anytime employees are working at home. And under normal circumstances, where an employer is just considering a work-at-home program, you know, we talk about putting into place remote work agreements that kind of cabin when they're working, where they're working, that it's an improved environment, and we do that to cabin risk. I'm sure that there are a large number of employers who well, nobody had time to even think about that. They've never had remote workers and they've just sent everyone home to work. And so that is legitimate. It's a legitimate concern.
Agree with that 100%. Under Maine's extreme public health emergency leave, would leave to care for an elderly / immunocompromised family member who was self-quarantined based on CDC advice be covered?
The answer is we don't have, I'm not aware of any case or interpretation of the statute, but I would interpret it broadly to cover, I think the prong was, employee is needed to provide care or assistance to spouse, domestic partner, parent, or child. If one of those people needed care as a result of, you know, a self-quarantine or anything, I would say yes, I would err on the side of providing them with leave. And keep in mind, it can be unpaid leave under that statute.
I'm going to ask one more question. Is the PPP loan forgiveness term clock immediately started when the loan is issued, or can it be used to restart operations once the pandemic has ended?
The loan forgiveness clock starts that 8-week, it's called the covered period. That 8-week period starts with loan origination. I don't know whether that, I assume that means when you get the money. Certainly it's not later than that. So no, yes, you could take the money and you could spend it on other things outside of the 8 weeks, but you will not be eligible for forgiveness. To be eligible for forgiveness, you must spend it during the 8 weeks and mostly on payroll. We are past noontime.
That is the extent of our presentation this morning. I'm sure you all join me in thanking Katie for her fabulous presentation, very informative. I have been asked a couple of times where the slides will be available. They will be on our website at www.mainchamber.org. Katie, I don't know if you're putting your slides up on the firm's website or not, but they'll be available on ours.
Great. And I suspect we will. Thank you, everyone. It was nice I wish I could have been in a room with all of you, but I guess this is the new normal.
This is the new normal. Thank you all very much and have a great day, and please stay safe.